and introduce Shaun, the speaker for today. So Shaun is a partner with Novation LLP, which has several years of experience both in public and private sector. Shaun's practice focuses on marketing, e-commerce, privacy, and access to information. And Shaun has also assisted the federal government in developing certain aspects of the Canadian anti-spam legislation. So I'm going to go ahead now and pass it over to Shaun.
Hi, thank you, Emily, and thank you to Michael and the people at Figure 8 for having me speak today. Just figuring out the slides here. Okay. Are you able to see the presentation, Emily?
I see your GoToWebinar, the website where it says download complete.
Okay. How about now?
I just have a blue screen.
Okay. You're going to have to run this from my computer. How about now?
Yeah, the slides are up.
Okay. Sorry about that. Again, I'd like to thank the people at Figure 8 for having me come and speak today. As everyone is aware, legislation was passed. It was actually a year ago tomorrow that the law received the royal assent. It's not yet in force. It's slated to come into force sometime in 2012. I'll speak a little bit more about this toward the end of my slides. But this is a fairly complex, lengthy piece of legislation. There are a lot of rules. As Michael pointed, there are a lot of rules and details that are yet to be finalized. So understandably, there are a lot of questions around the legislation, how it's going to apply, which is even more important given the potential significance of some of the penalties in the legislation. So I'm only planning to speak for about 15 or 20 minutes at a fairly high level to leave lots of time for questions so that we can get into a little bit more detail towards the end. Just look at the primary requirements and rules, an overview of the enforcement and penalty regime, a look at next steps in terms of regulations and coming into force, and then leave lots of time for questions at the end. Broadly speaking, CASL, Canada's anti-spam legislation, which is an informal name, the law was actually passed without a short title. It does a number of things, which is one of the primary things that really sets it apart from laws that we see in other jurisdictions. So first and foremost, and what we're going to focus on today, CASL is an anti-spam law. It establishes rules for the sending of commercial electronic messages. It's also intended to be anti-malware. So it creates rules for the installation of computer programs on computers and other devices. There is a provision in there intended to deal with hacking and the alteration of transmission data. So we're looking at more nefarious type things, phishing and farming attacks. There are amendments to the Competition Act to deal with false and misleading information, specifically in commercial electronic messages. And also, finally, our federal privacy legislation, PIPEDA, has been amended to attempt to address more specifically. We have address harvesting, which is where a technique where senders will go out and crawl the web for email addresses and other electronic addresses, and dictionary attacks, where we use software to automatically generate electronic addresses, and using telecommunications to remotely access computer systems and attempt to steal personal information. So when we're talking about the anti-spam commercial electronic messaging rules, when we look at the application of these rules, it's very, very broad in a few important ways. First, in terms of jurisdiction, the anti-spam rules apply to any message that is sent from or accessed by a computer system located in Canada. So in other words, it applies to any message sent to or from Canada, meaning that it applies to senders around the world if they're sending to Canadians, whether they know it or not. It's a lot more than just email. You know, email is still the primary focus in a lot of cases, and what we'll focus on today. It potentially applies to any form of electronic messaging, so instant messaging, SMS, text messaging, certain types of messaging through social media. The way that the law is drafted, by definition, it would currently include voice and fax messaging, though they have been explicitly carved out of the law for the time being. Given that they're covered by our do not call rules, though there is a provision in the legislation which could be brought into force through regulation, which would effectively bring voice and fax within the gambit of the same rules, and at the same time kill the do not call list. And obviously there's no minimum number of messages that need to be sent at any given time in order to be caught. So a single message can be considered or result in a violation of the rules. One of the most important definitions under the legislation, obviously, is the commercial electronic message. And again, we get back to that theme of the government doing everything they can to make the law as broad as possible. A commercial electronic message is very broadly defined in terms of what is deemed to be commercial. A non-exhaustive list of examples that's provided right in the law: anything that promotes a product or service, a business opportunity, or they explicitly spell out even if the message promotes an individual who does any of those two things. So a primary example is an email message with a picture of a real estate agent promoting that real estate agent, even though it might not make any offers or promote any of their specific services, because you know that's a real estate agent and what the real estate agent does, then it would be caught by the rules. And just to make things crystal clear in the legislation, any message sent to request consent is deemed to be a commercial electronic message. So a bit of a catch-22, but the policymakers felt it was important to have that in there. I can't send you an email message to ask you if I can then follow up with a commercial electronic message. When we look at the commercial electronic messaging regime, there are three primary rules. The first and foremost is consent. And then we have the identification and unsubscribe requirements, the latter two of which are generally quite similar to what we see under CAN-SPAM. So I'm assuming that most people on the call today have some experience implementing these requirements, although there is the potential, particularly through regulation, that these requirements could be altered and potentially made a little bit more onerous. When we talk about consent, this is one of the primary ways in which CASL is distinguished from CAN-SPAM, because obviously there's no consent requirement under CAN-SPAM. This is a permission-based regime, meaning that you need some form of consent before you can send a commercial electronic message. Now, consent can either be expressed or implied. When we talk about express consent, the legislation doesn't spell out or define what express consent means, and that was intentionally done to allow for flexibility and practices and rules to evolve and develop through application and interpretation of the legislation. And hopefully, I would like to see the CRTC, who's responsible for enforcing, draw on the experiences of the Privacy Commissioner under privacy legislation, given that there's about a decade of experience there in terms of understanding and implying what express consent means. Now, what the law does say is that notice has to be very clear, meaning that in most or all cases, it's unlikely to be sufficient to bury a term in a privacy policy or terms of use. So it needs to be brought out. It needs to be brought specifically to the attention of the individual. You need to describe the purposes for which you're obtaining consent. Are you obtaining consent just to send email? Is it consent also to send text messages? Are you only sending your own messaging, or are you potentially advertising on behalf of third parties? These are all things that should be clarified at the time when consent is obtained. And the law also requires that you provide certain prescribed information, which is defined in regulations. And I'll talk a little bit more about this, but we saw a glimpse during the first draft of proposed regulations that were published this summer. And to be honest, the requirements in there were, I think, a little bit ridiculous in terms of the amount of information that was required to be disclosed. So I hope and assume they've gone back to the drawing board on those requirements, and we'll see less onerous regulations on these issues in the new year. We often talk about opt-in versus opt-out, and one of the most common questions that arises is whether, if we have a statement saying, I would like to receive communications from so-and-so, and there's a checkbox, can the box be pre-checked, or does it have to be unchecked? And at this point, we can't really say for sure. A lot of cases under PIPEDA, that would likely be acceptable. Whether that is going to be acceptable under CASL, we can't really say with any certainty right now. And then we have the implied consent provisions. And I really refer to this more as a deemed consent, because instead of having an open-ended implied consent provision like we see under privacy legislation that allows you to infer consent if the circumstances are reasonable, this really deems consent to exist in 4 specific circumstances, 2 of which are likely to be most important. From a business to consumer perspective, the existing business relationship is important, which effectively says that you have implied consent to send a commercial electronic message to someone if you've done business with them in the past 2 years. So this is automatically going to qualify a large number of individuals based on the fact that you've done business with them in the past and if they're in your system. And then in terms of business-to-business communications, the conspicuous publication of electronic address is likely going to be quite important, which effectively says that if someone has published their electronic address, for example, on a website, and they haven't included a statement that says, please do not send me unsolicited communications, and the third condition, which is important, any message sent to that electronic address has to be relevant to the individual's professional capacity. Now, just how relevant that message has to be to what they do is somewhat up in the air, and something we'll have to wait to see as the law is interpreted and applied. Identification. Every message has to identify the person who's sending it, as well as the person on whose behalf the message is sent if you're sending it on behalf of someone else. Contact information for one of those parties, and also the regulations will be important on this. I referred to them already. The regulations also establish rules for the types of information that have to be included in every commercial electronic message. And finally, we have an unsubscribe mechanism. Again, generally consistent with what we see under CAN-SPAM. Few small differences under CAN-SPAM. The mechanism has to be functional for 30. They've said 60 days here. It has to be available at no cost, using the same means unless impracticable, meaning if you're sending me an email, don't make me call on a telephone number. Every message must have either an electronic address or a link. So again, if we're looking at email, it could be an email address. You could say reply to this email, or you can have a link to the web where they go through the online preferences page or opt-out page. This last point, which causes a little bit of confusion because, to be honest, it's quite unclear what this means. They've said that an unsubscribe request must be processed without delay. Don't really know what without delay means. I think the intention is for every request to be processed immediately, but then it goes on to say in any other event no later than 10 business days. So that looks a little bit more like what we see in a canned spam. I think what is likely to come out of this is that organizations are going to be required to demonstrate that they've instituted best efforts to make sure that once request to unsubscribe has been received, that no more messages are sent. Just very briefly about liability for service providers, there is a provision in the legislation on an exemption from liability for telecommunications service providers, which says that a TSP can't be liable for merely providing a telecommunications service which enables a transmission of the message. The most obvious example is an internet service provider, an ISP, because they transmit millions, billions of messages every day. You don't want them to be liable for spam. The extent to which this exemption would be available to other providers, such as agencies or more relevant email service providers, will likely depend on a number of factors, including the types and level of services that are being offered, the extent to which the service provider is involved in building and managing lists and actually deploying the messages. Moving on to enforcement and penalties, CASL has been created with a combination of public and private enforcement. So on the public side, the enforcement agency who is responsible for the legislation is the Canadian Radio, Television and Telecommunications Commission, or the CRTC. This is building on the role of the CRTC as an enforcement agency under the Do Not Call rules. They've been given fairly extensive powers to be able to investigate and compel information. The most important power given to the CRTC is the ability to impose administrative monetary penalties, or AMPs. And these are the big numbers that you sometimes hear about. With respect to the anti-spam provisions, the legislation allows for an AMP of up to $10 million per violation. So that's for potentially every single email that's sent. So if you send 100 emails in contravention of the legislation, you could potentially get hit with a $10 million penalty for each one of those emails. Just astronomical. It sounds pretty ridiculous. The policy reason for doing this is that it's always argued that for spammers, unless the penalties are astronomical, they'll just look at the occasional penalty as a cost of doing business because they make so much money. They've put a significant amount of flexibility in there in terms of the amount of penalties that the CRTC actually has to impose. So they don't have to impose a $10 million penalty. They don't have to impose any penalties at all. But nonetheless, it's still potentially quite concerning. And on the private side, we have a private right of action. Again, this is one of the key differences from canned spam. Canned spam also has a private right of action, but it's only available to providers of internet access services. Under CASL, the private right of action is available to any person who is affected by a violation of CASL, as well as the related amendments to the Competition Act in PIPEDA. And in addition, given the difficulty in cases like this, often in terms of being able to demonstrate that someone has suffered actual damages, the law allows for actual as well as statutory damages. So when we look at statutory damages for commercial electronic messages, the statutory maximum amount under CASL for statutory damages is $200 per email. So there's definitely the potential to see class actions under CASL, as well as actions by businesses who are affected by spam. So it could be ISPs and banks and other organizations. So as we already know, the law isn't yet enforced. It's been a year now. Expecting to see it enforced sometime, looking more like the middle of 2012 in terms of what still needs to be accomplished by the government. The regulations, as I mentioned, regulations were published in the summer. So the responsibility for making regulations is divided among the CRTC as well as Industry Canada, and they both published sets of proposed regulations in the summer. There were a significant number of comments, particularly on the CRTC regulations, which were quite onerous and I think out of step with realistic business practices in terms of what was required for senders. So they've gone back. They've obviously reviewed the comments, and I'm expecting to see a further round of draft regulations published in early 2012. I'm hoping to see them. In terms of coming into force, I think the government will have to give industry at least 90 days following the finalizing of the regulations. So if we sort of add in that 3-month period, I think we're looking at least mid-2012. And the government is also in the process of putting together a spam reporting center, which is basically a Canadian version of the FTC spam fridge. So this is a place where anyone can forward complaints and examples of spam and other threats, and in theory anyways will form a repository that the CRTC can use to then institute enforcement actions. I've added in a couple slides here on the key differences from CAN-SPAM. I'm not going to go through them, but they're in the slides, and I'm assuming everyone will have access to them afterwards. It's basically a recap of what we've already discussed. In terms of preparing for CASL coming into force, obviously we have to wait on the regulations in terms of completing the preparation, but there are certain things that can be done now in terms of checking your lists, making sure that you have consent, determining whether consent is expressed or implied. If implied consent, when might that consent expire? And also very important is the law expressly says that anyone claiming to have consent bears the onus of proving that they have consent. So even if you think you have consent or know you have consent, you want to be able to prove that you have consent. So make sure that you have the appropriate records. In some cases, reconfirmation, I know it's a dirty word that nobody likes to hear, but it might be necessary. And again, just watch for the regulations in terms of content of messages and the rules required around obtaining consent. So that's the end of the formal part of the presentation. Now I'm happy to do my best to answer any questions that anybody might have.
Okay, awesome. That was great. Okay, so the first question that we have, let me just pull it up here. So the question is, a lot of email lists that can be rented in Canada provide a message or campaign set by the list owner, example, a publisher. So if the publisher's list contravenes the act, is the person who has rented the list culpable as well?
That's a good question. I would say potentially. The law has been drafted in a way keeping with this theme of breadth, that they've done everything they can to extend liability as far up and down and across the chain as possible. So not only are you liable if you send a message, you're liable if you cause or procure or induce a message to be sent in contrary to the legislation. Now, if the publisher has done something wrong, and they violated legislation. The CRTC comes after you're named in an action. Usually what happens is every party who's involved will have to respond in one way or another. In circumstances like this, it really pays to do your due diligence beforehand. So in terms of finding out who the publisher is, what's their reputation, and most important are your agreements. Having provisions in there to deal with liability and clauses saying that you as the publisher, you have certain obligations to make sure that every message that is sent out is in compliance with the legislation.
Okay. So the next question refers to your implied consent slide, number 3, conspicuous publication of electronic address. And the question is this effective from when CASL is implemented, or is it retroactive? So for example, if a person's email is attached to a blog from 8 years ago, is that called an eventual send to fair game or for spamming?
The law actually has a sort of grandfather clause included in there to deal specifically with this. And what it does is effectively extend the period from 2 years to 3 years. So if you have, sorry, we're talking about conspicuous publication of a electronic address here. Sorry, okay. I was moving on to existing business relationship. In terms of the conspicuous publication, it would come down to whether the address is still published. So if you're saying that you have a blog post and it's still online that someone has attached an email address to?
Yeah, I believe that's what they're getting
at. Yeah, that's a good question. I think something like that you'd have to use common sense. If it looks like an address that was just left in a blog post 8 years ago, depending on where it is on the page, you might not even fall within the conspicuous publication. There are obviously going to be some gray areas there, but one of the obvious things that come out of that requirement in the legislation is that it has to be shown that, or it has to be reasonable to assume that the individual has actually published their address. So do they even know that it's still online? That's a lot different than publishing it in a directory or publishing it on a website. So I would be careful about digging back too far.
Okay. So the next question we have here is, what impact will this have on non-Canadians who are spammers? How will the law be enforced?
That's a really good question that a lot of people who are more critical of the legislation have. They basically say that a lot of the worst spammers aren't even in Canada, so how are you going to go after them? If we're talking about spammers who are in Russia, I think the law is likely to have very little impact and reach. If we're looking at spammers who are in the United States, going back to the division between public and private enforcement, the public enforcement side is less likely to have, in my view, a lot of impact on non-Canadian senders, because even if they investigate and they impose a large administrative monetary penalty, generally speaking, those penalties can't be enforced in other jurisdictions. Now, what the CRTC might do is they might go to the FTC and try to find out if the FTC has jurisdiction, if they have violated CAN-SPAM or any other law in the U.S., if there's something the FTC can do to go after them. But on the other side of things, especially when we're dealing with more established companies as opposed to the clear spammers, private right of action is something that can potentially be enforced in other jurisdictions. Increasingly, we see the willingness of countries to recognize judgments in foreign jurisdictions. We have that in Canada. And as a primary example, there is a fellow by the name of Adam Guerbez who lives in Montreal, a notorious spammer. He had actually, according to Facebook, he had hacked into a number of Facebook accounts and used those accounts to then send spam. He was sued by Facebook in California And they were successful because he didn't show up to defend himself for approximately $780 million. And they were actually able to come to Quebec and have it enforced in Quebec as if it was a Canadian judgment. So he now owes Facebook somewhere in the realm of $1 billion Canadian. So when we're looking at the private right of action, there is the ability, in theory at least, for organizations to be sued in Canada and then have those judgments enforced in the jurisdiction in which they operate.
Okay. So the next question, we actually had two very similar questions. They both go back to implied consent. So one was more in a retail respect. If a customer provides their email verbally to a checkout person in a store, what options would we have to prove consent? And the next one was, if you're given a business card, does that imply consent?
Okay, I'll deal with the retail example first. Interestingly, when the first round of CRGC regulations were published, it actually said that a request for consent had to be in writing. So it effectively precluded the ability to obtain consent orally. There were a lot of comments on that regulation, and I'd like to think that we won't see it in the next round of regulations. With respect to proving that you have consent, one option, and I think this is the minimum that you should do, is that when you plug it into your system, so assuming that you're at a computer terminal, you ask for the email address, you enter it in. In most cases, there's going to be a time and date stamp for when that record was created, likely coincide with the fact that a purchase was made at that time. So I would like to think that that would serve as sufficient evidence that you've obtained consent. If you want to be a little bit more conservative and diligent, you can actually have the individual write it down on a piece of paper. A little card that says, I would like to receive commercial electronic messages, and then you give that to them to fill out while you're processing the transaction. Moving on to the, the second question.
The business card, if someone gives you a business card.
The law explicitly says that you can contact someone if they've provided you with their electronic address directly. And again, the message has to be related to the person's professional capacity. Now, whether handing over a business card would suffice, I would like to think so, because generally you hand over a business card with the expectation that someone is going to contact you. I can't say for certain, but it would seem quite illogical to me if that wouldn't qualify under the implied consent provisions.
Okay. So the next question we have, transactional messages are still allowed to be sent without consent, but could you be held liable if your transactional message contained a commercial message or snippet?
Yeah, so the transactional messages, that's a concept that exists under CAN-SPAM. It doesn't exist under CASL. That being said, there are a class of commercial electronic messages that would overlap to a significant degree with what is considered transactional and relational under CAN-SPAM. So that category of messages was added to the legislation as a result of comments during the committee review of the legislation. And people made comments like, well, the law shouldn't apply to information providing updates or warranty information or anything like that, which makes sense. In my view, the simple response is that if that's all you're doing and there's no commercial content, it's not a commercial electronic address. Sorry, it's not a commercial electronic message. But they added that category of messages to the legislation anyway, and said if you're doing any of the following, if you're only doing any of the following, then you don't need consent, but the identification and unsubscribe requirements still apply. But the key condition there is that it has to solely do one of the following. So the implication is that you can't have any commercial content whatsoever, which sets it apart from canned spam, which allows for, so it includes the concept of the primary purpose. So if the primary purpose is transactional relational, and even though there's some commercial content in there, it still falls within those rules. Under CASL, that concept doesn't apply. So a short answer to the question is that if there's any commercial content whatsoever, it's a commercial electronic message, and the rules apply.
Okay. Okay, so the next question we have is, under CASL, will a single opt-in be sufficient when an individual wishes to subscribe to your e-newsletter, or will a double opt-in be required by law? So where double opt-in requires person to subscribe via form on your website, and then you send them a confirmation email where he or she clicks on the opt-in to confirm subscription.
Right. The law doesn't go into that level of detail and granularity in terms of single opt-in versus double opt-in. Off the top of my head, I can't see of a situation where the law would actually be interpreted to say that you needed double opt-in in this circumstance. Now, the obvious example having double opt-in is that it provides even stronger evidence to demonstrate that you actually did have express consent, but not the way the law is currently drafted. I think it would be hard to say that double opt-in is actually a legal requirement. Obviously, there are other reasons for using double opt-in, one of the most important being that it cuts down on potentially a number of complaints that you might receive, but not a legal requirement.
Okay. So we have a scenario here with the question. So someone said, an industry association publishes a list of members. Some of these associations directories are online and include addresses and emails. If someone harvests these emails and sends business correspondence, they understood that these were not opt-in unless can be proven. Has this changed at all with the new act?
So just to clarify what you're saying, under existing best practices, if a trade publication has published a list of email addresses, it's not okay to send to them. Is that the question?
I think so. Yeah. I think that's what they're getting at.
In terms of being able to send to a list of emails that have been published, if we look at the implied consent provisions in the conspicuous publication of electronic address, again, we'd have to look to whether there were any no solicitation clauses included with that list, and again, sort of use a bit of judgment in terms of, well, whether you suspect the individual even knows that their electronic address has been published. Like, has that directly been published by the trade association? And do the individuals know they've been published, or has it been published by a third party who has no relation to the individuals? And again, it goes back to the need to make sure that the messages that are sent are relevant to the individual's professional capacity. So it's hard to say that there's a hard and steady rule in this case. It would tend to be context specific.
Okay. So I think we'll just ask one more question here. So someone says, with regards to unsubscribes, in the case where someone receives an email from a company with multiple brands, when they unsubscribe, who are they unsubscribing from? What is the best practice to sort of handle this situation?
Again, I think there are different ways to address this, depending on the circumstances. One question that I would ask is, was it just a single point of opt-in from the outset, and what did that opt-in look like? So did they know that they were opting into multiple brands? Is it one brand within a group of brands, and the individual thought they were only opting into a single brand, but were opted into a number of other brands without them knowing? Did the opt-in say that you're opting into receiving offers from these 4 or 5 brands or this group of companies. So there are a lot of factors that could play into that, and also what does the opt-out look like? So is it a single unsubscribe? You're unsubscribing from this list, or do you give them the option? So they click on a link which goes to a preference center, and you possibly spell out a number of different brands. And you could ask the individual, do you want to hear from these brands but not these brands, and give them the choice. That's one of the benefits of using a preference center, is that you have more flexibility in terms of how the individual and from what lists and brands they're potentially unsubscribing from.
Okay. Okay. So there were also, I just want to point out, there was a lot of questions regarding the strategic audit that Michael Greaves spoke about at before the webinar. So if you do have any questions about that, please email me, Emily, at ecornelius, ECORNELIUS, at vigoratedigital.com, and I'll get you all the information and everything you'll need for that. But other than that, I would like to thank Shaun, first of all, for coming on and doing this presentation for us. And I'd also like to thank everyone who attended the webinar. I think it was very insightful. And just wanted to point out also, we will be doing 2 more webinars in the next year as the bill gets closer.